Thank you. We're looking into what happens when an attorney is in trouble with the law. A Hamilton County attorney was indicted for forgery this week. Alan Norton represents former Chattanooga Police Chief Celeste Murphy. A Ray County grand jury indicted him on forgery and criminal simulation charges. The TBI says he is accused of forging the signature of a 12th Judicial District Chancellor on court documents. Now, this accusation is not connected to the Murphy case.
So what happens when your lawyer is the one facing charges?
Grayson Gordon spoke with the former Tennessee Association of Criminal Defense Lawyers president to get some answers.
When allegations are made against a lawyer, the Tennessee Board of Professional Responsibility, overseen by the state Supreme Court, steps in to determine if they can continue to practice while the case is being handled. Summers Rufolo and Rodgers attorney and former president of the Tennessee Association of Criminal Defense Lawyers, Ben McGowan, breaks this down.
The board has certain criteria that they consider in determining whether that lawyer's license should be suspended.
That criteria includes either a person misusing their role as a lawyer, like misappropriating client funds, or cases of substantial harm to the public.
Since it's a decision that's impacting someone's livelihood, the board has to take a very careful notice of what the allegations are, now remembering that they are not facts at that point.
If they are not suspended, they can continue to practice as normal while the case moves through the court system. Although the board can decide to limit what a lawyer can do while an investigation is ongoing if they see it necessary. When we're talking about the client, if that attorney is still allowed to practice, it's really up to them to determine whether or not they want to move forward with that representation. On the other side, the attorney can determine that it's in the best interest of the client to seek alternate representation.
There are many times when a lawyer and client can discuss those things openly, and the lawyer and the client can make an independent assessment over whether the allegations really do affect the lawyer's competence to practice and to represent them.
If a lawyer is convicted of a crime that constitutes suspension or disbarment, that action is immediate. They may be allowed 30 days to get client affairs in order, although they cannot accept any payment.
The lawyer may need to wrap up matters and transition those cases to someone else to handle them.
If they are not convicted, an attorney can still face disciplinary action from the board.
Someone can be acquitted in a criminal matter and still face bar discipline and a bar disciplinary proceeding, even if they have been found by a jury that appears to be not responsible or not guilty.
Reporting in Hamilton County, Grayson Gordon, Local 3 News.